Hello, good evening, everybody. My name is Rod Escayola, and I'm your condominium lawyer with Gowling WLG. Thanks for joining us today. Today is the June edition of the Condo Advisor webinars, and today is our last episode of the season. It's our summer edition, and I got to tell you, we had so much fun last December when we invited our condo lawyer friends from different firms that we decided to repeat the event. So we've invited a big bunch of condominium lawyers. You'll recognize their faces, maybe not their clothes. And so today is going to be, this week is going to be what I dare to call our first annual Lola Palooza episode, during which we will cover recent cases. There's some crazy cases out there. And so each of these lawyers that I'll introduce in a minute will be presenting a recent case that caught their attention. Before I forget, a couple of events that are coming up that are of interest probably to some of you. And Graham, I didn't give you a heads up, but maybe if you're able to put some links in the chat. So the first event is a huge event in the GTA. For those of you who are in the GTA area or who don't mind traveling, next week, CAI Canada is holding a, wait for it, in-person condo conference, and it's going to be done in conjunction with the Remy show. It's going to be amazing. The speakers are amazing, the lineup's amazing. There's going to be booths, there's going to be all sorts of stuff. So if you're in the area, it's on June 8th and June 9th. So Graham, if you're able to find, maybe not right now, but if you're able to find maybe the link to CAI Canada.
I got it, it's already in the chat.
Wonderful. Okay, perfect. The second event that may be of interest is on June 14th. So that's Tuesday, June 14th. The Condo Directors Group will hold an online event. They do them during the evenings. It's 7 p.m. to 9 p.m. So this month, it's a quarterly event. This month they'll take a deep dive on condominium pets. It's going to be about what rules are out there. They just launched a survey. So what rules are common, how do you adopt a rule, how you change a rule, how do you evict a pet, accommodations, and so on and so forth. So that should be a good one too. And if you're able, Graham, to put a link, that'd be fantastic. Okay, so let me just put my sunglasses on. Let me stop sharing my screen. We are going to introduce our panel. Wait for that, folks. It's going to be something else. So I wasn't going to start with you just because of your outfit, but it's just a coincidence I'm starting with you. Our first guest, the condo lawyer with the best looking smile from Shively-Ryden, the Maytag repairman of the condo bar, Patrick Greco. Patrick, look at you. That's fantastic.
Thanks, Rod. Hi, everyone.
So, Patrick, we thought we would introduce our panelists with their most memorable job. And I don't mean hit job. I mean like something like maybe a summer job or something. What would be your most memorable summer job?
Well, I am from Hamilton, so both could have applied. But my most memorable summer job was working at the Camco Appliance Factory on Longwood Road in Hamilton. It's not even there anymore. Probably who knows what I inhaled, making hot loops. And I had to make 600 hot loops at a station alone all day. And for those of you who aren't in on the fridge lingo, the hot loop is a figure 8 shaped thingy that does something in the two doors of your fridge. I never really thought to ask, so I had to look it up yesterday, but I'll never forget hot loops.
Nice. Okay, so now we know to look for the hot loop. The next speaker, also a returning guest. We're very lucky to have this person here from Hodis Law. Barry's Wild Berry, Sonia Hodis. Hello, Sonia.
Hi, Rod. Thanks for having me back. And I hope I met the dress code for today.
Yeah, for sure. And so what's your summer job that you want that left a mark maybe?
Yeah, well, this job is what actually made me go back to school and go to law school, because I spent one summer picking wild blueberries. And for anybody that complains about the price of wild blueberries, don't, because it is absolutely horrendous to have to pick those things. I think I almost had to pay them for that job because I made such little money because I couldn't pick enough. So yeah, wild blueberry picker.
Nice. I think if I had that job, they would have to weigh me on the way in and on the way out because I'm not sure that I'd pick them. I think I'd be eating all of them. So new to this webinar from Robson Carpenter, our one and only undercover condo lawyer, Justin Black. Hi, Justin.
Hello.
Hey, what's a summer job that left a mark?
All throughout university, I worked for an underground cable subcontractor where the cables were too expensive to use heavy machinery. So it was myself and a shovel all summer long digging holes. So the saying the world needs ditch diggers, I was literally a ditch digger. Incredible work. Makes
Nice.
me appreciate being in the office, except now I get to watch people outside in the sun and I'm jealous of them. But
Must have
we are.
also given you a great tan, a farmer's tan.
Absolutely.
A returning guest, in fact, truly, because we've had the privilege of having her on quite a few occasions. And you may remember her as the axe-throwing condo lawyer from Lash Condo Law. We have Natalia Polis. Hi, Natalia.
Hi, Rob. Thanks for having me back.
So tell me about a job that is memorable.
So this job actually pretty much led me to where I am today. I actually worked for my mom's property management company as an assistant property manager prior to the whole licensing requirements for pretty much every summer of my undergrad. So that's how I entered Condoland, and I guess it left a mark since I'm still here.
Nice, nice. Good. Now, folks, the last but not the least of our returning guests, well, not a returning guest, this one is new to the show, but someone I've known for a long time. We've blogged together in the past, we've presented together in the past, and with a look that would make him fit right in with the Condo twins, we have from Miller Thompson, Jason Rivet. Hi, Jason.
Hey, Rod. Thanks for having me. Hey, everyone.
So, Jason, what's the summer job you want to share with us?
For a couple summers, worked at Canada Customs protecting the Windsor border from all the riffraff that would come over. So we dealt with bingo mamas to gangbangers and everything in between. It was a great summer job. I frankly have stories that maybe I can't share online here, but
not at 5 o'clock.
Perhaps
Yeah.
another day. Yeah.
Right, not before supper, because I know some of these some of these stories. Okay, fantastic. So if you ever have a beer with Jason, just bring that up. I think they're pretty entertaining. And of course, your one and only Condo twins. And the first one actually volunteered with a foreign army, believe it or not. Looking good with
thunder.
Oh, well, I thought you fed me that line.
That's true.
Looking good with a tie or with combat boots. Super Dave. Hi, David.
Hey, good evening. And yes, I don't know if it counts as a job because I was paid in room and board and the opportunity to travel and have fun. But yes, I volunteered for a month in a foreign army, packing reservist bags and other assorted things on a disputed border.
People can connect the dots that they want to connect. Fantastic. The second twin, the evil one, has handled trench warfare as well, like no other. The original Grizzly Adam, Graham McPherson. Hi, Graham.
Hi, Rod.
So-
So I'll cut right to the chase. My probably most memorable summer job, and the one I had, my job immediately before becoming a lawyer, was I worked at a trailer park for 5 years, working my way up from custodian to supervisor. And you may be asking, well, what extra benefits or responsibilities came with being supervisor? And it meant that I got to make the schedule to decide when the other custodians, including myself, would come in.
Nice. So I did refer to you as Grizzly Adam, but that's before I saw your outfit. I should have gone for Magnum PI, actually. That's who should have gone with. And those people at home, just so you know, there's a person on the panel that was not actually invited to dress up and showed up dressed up this way. Patrick, you look fantastic. This is phenomenal.
Thanks, Rod.
Okay, so let's start. We got quite a lot to cover, and I'm going to follow if I can find the agenda, and maybe I can't find the agenda. And so we're just gonna go. Anybody remembers who's going first while I look for my agenda?
I think it was me, Rod.
You think it was you. So let me just maybe do a very quick introduction. You are going to talk about, all right, it's raining cats and dogs from the balcony above. a couple of cases, or at least one case from the Condo Authority Tribunal dealing with leaky cats.
So I'm actually talking about the other case, the Toronto Standard Condominium Corporation numbers 1767 and Ahmed. This case actually pertains to a dog, but also a leaky dog, I would say. I actually argued the case before the Condominium Authority Tribunal and dealt with all the debacle prior to. So a little bit of background info before we get into the actual facts of the case. So prior to commencing the application, the corporation and our office worked with the owner to try to get the tenants who had a dog that would urinate, defecate, all of the like on the balcony to stop doing so. We took multiple enforcement steps, providing notices, first from management, then to from legal counsel, and ultimately tried to work with the owner cooperatively to try to come to some sort of resolution for this to stop. Of course, since there's now this decision, it didn't stop. So the corporation brought the application against the tenants as the respondents, and then the owner was listed as an intervener. The application initially sought to obtain an order for the removal of the tenant's dog as it was deemed a nuisance for obvious reasons. It's continuous urination, defecation, etc. on the common element balcony. They also sought enforcement costs that the corporation incurred prior to the application. So that was our legal involvement, legal letters, and so forth. And then the cost of cleanup. So because the balconies below this offending unit's balcony were soiled with all sorts of waste and excrements, the corporation had retained its own cleaners to go on those balconies and to remediate the damage that was caused. And the last item was the actual costs of the application were sought. So during the mediation phase, the tenant and landlord actually appeared before the landlord and tenant board, and they were able to come to an agreement and settle, being that the tenant and the dog would move out of the corporation within a month's time or something along those lines. This caused part of the application to essentially become moot. The order for the removal of the dog was no longer required as the dog was being removed voluntarily along with the tenants. So there were 3 items left, and those are the 3 costs that were being sought. The first of these costs were the cleanup costs. So the Condo Authority Tribunal found that the corporation had the responsibility to clean up the soiled balconies in the absence of any action taken by the owner or tenant. Although the owner said that he had obtained quotes from different cleaners that were lower than the cost that the corporation had incurred, they never actually took any steps to go on those balconies or attempt to clean them on their own, and neither did the tenant. So CAT found that the costs that the corporation incurred, being $3,044.60, were reasonable given the circumstances. So now the case really fell on who pays for these costs. And the same line of reasoning basically follows suit for the remainder of the costs being sought. The corporation initially sought these costs jointly and severally against the owner and the tenant. And the reason for doing so was that they were aware that the owner had taken reasonable steps. They were aware that the owner was doing things to try to obtain compliance and to avoid the situation from reoccurring. The corporation's rules provided that the owner of the pet was responsible for any damage to the common elements caused by its pet. The declaration, on the other hand, had a bit of different language, which provided that liability ultimately onto the owner. What the interesting part of this case was is the corporation had previously acknowledged the owner's assistance in trying to remove the tenant and their dog, and made representations that they would not seek any costs against the owner, but would seek those costs against the tenant. So CAT ultimately looked at this acknowledgement and this representation as a deciding factor, in my opinion, why the CAT ordered the cost to be paid against the tenant. So they ordered that the tenants pay the entirety of the $3,000 and change rather than the owner. The second item were the costs of enforcement. So the corporation argued that the owner or the tenant should be responsible for the enforcement costs, being $1,400 and change. That includes legal letters, anything prior to the actual commencement of the application. The owner argued that he should not be responsible for these costs, as the corporation had known all along that he was taking action. He brought a proceeding before the landlord and tenant board to try to seek their eviction, and noted that the corporation should have just waited and held tight until there was a result from his own enforcement steps. The corporation argued that we had the obligation to enforce the governing documents. We were never party to the landlord tenant board application. We had no idea or could have predicted the outcome of this sort of application. And as many who may have attended landlord and tenant board in the past or have any sort of knowledge of it, it does take a long time, like any sort of court proceeding. And sometimes it seems like the landlord and tenant board favors the tenant over the owner. So they had no idea how this was going to result. CAT agreed with the corporation in this case that they had the obligation to enforce its governing documents. They had the obligation to take further enforcement steps, and ultimately were able to bring this application. Again, the CAT looked at that representation made in the past to the owner about costs, and then ordered these costs to be payable by the tenant only and not the owner. The third costs were the costs of the actual application itself. So all the legal fees incurred after the application commenced from stage 1, 2, and ultimately stage 3. As we've seen in multiple other CAT decisions in the past, the CAT is reluctant to award legal fees for the costs of the actual proceeding. So the same thing followed suit here. CAT relied on a previous iteration of its rules when deciding about whether or not CAT should award any of the costs during the application. And that rule provides that the CAT will not order a user to pay another user any fees charged by that user's lawyer or paralegal unless there are exceptional reasons to do so. That exceptional reason test, as it was previously noted in the rules, is a pretty high threshold to clear. In this case, there actually were many delays that we argued were exceptional circumstances, many of which were basically a rotating door of summer students representing the tenants. Ultimately, the CAT did not find that this met the exceptional reasons test, and they did not order any costs of the actual proceeding. So just one thing to note, the rule has now changed. It no longer has the exceptional circumstances tests. However, it provides that CAT may order a party to pay another party's costs, including the costs that were directly related to a party's behavior that were unreasonable, undertaken for an improper purpose, or caused by a delay or additional expense. So that rule has now changed. So a couple of takeaways from this case before we basically open the floor. The corporation does not have to wait to take further enforcement steps if they are aware that an owner is trying to obtain compliance. They can take those steps, commence an application, whether before CAT or otherwise, even if they know that an owner is taking reasonable enforcement steps. Of course, like any case, it's fact specific. So that determination has to be made likely with consultation with your legal counsel. And then the last takeaway, and I think this is the important one, is generally owners are responsible for their tenants' actions. And this is listed in the Condominium Act, the declaration, rules, etc. However, making certain representations about not seeking costs if an owner is acting reasonably may come to bite you in the butt in the future. So just to be careful about that moving forward.
Okay, so Graham's going to launch a poll, and the poll is going to be, do we think that the right side won on this case? So Natalia, in 12 words or less, like, so who won here? Who ended up paying for the cost?
So the tenants ended up paying the costs of the cleanup fees, as well as compliance costs prior to the proceeding, but those were minimal compared to the actual costs of the application itself. So who won? I mean, they got the dog out and the tenants out, which was what they ultimately wanted, but at what price?
So Graham launched a poll. Anybody want, and so everybody at home, you can vote whether you agree with the result of the case or not. Did somebody want to add something? I'm not sure who was going to sort of rebut. That's not really a rebut, it's just a comment on it. Was it you, Sonia? I'm not sure.
I think it was me. Oh, sorry.
Oh,
Go
no,
ahead, Jay.
go ahead.
Yeah, go ahead.
Yeah, so I think one's more of a question for Natalia, and then maybe the other's a comment. So the question I have, so you talked about the exceptional reasons test not being met. And to me, it was a bit of a head scratcher a little bit because, and I think you argued the Sophomus case, which was a great decision. The corporation took progressive escalation steps, clearly kind of laid that out. Similarly, there was a little bit of a gap in time maybe here, but similar fact pattern, but for the representation that they weren't going to seek costs against the owner. I'm wondering if there were other factors at play here that resulted in the decision, such as the fact that the summer students were representing, sometimes the law doesn't necessarily win the day. Sometimes some other facts are at play. You had a very responsive owner who was playing ball. Do you think those facts played into any of that decision at all?
I think you'll have to tune in next time because we're running out of time. I'm sorry, Jason, and the next speaker will have a bit less time because we need to sort of end around 6 o'clock. So, I mean, good comments, good case. Grim, share the results of the poll, please. I'm sorry I'm pushing you folks forward. We're going to move to the next case. Thank you, Natalia and Jason, for this one. I'm going to turn to you, David, and you are going to cover the Jasper versus YCC something case. I don't have the number here, 1903, no, whichever it is. But this case is about whether or not a group of owners are entitled to get a neutral chair to chair their meeting.
Yeah, so this case is about two issues, but since we only have time for one, I'll stick to the more interesting one, which is the neutral chair. There was a bit of discussion about proxies and whether you can use fillable forms or the condo is able to impose printed off colored forms. That's a battle for another day, and that's basically what the court said anyways on that issue. But on the issue of the neutral chair, so this is a long litigation that's been going on between party who owns a number of units. I don't know if it's a developer or some other corporate entity. And one of their representative was running for a director position on a platform to repeal a very large special assessment. And they preemptively brought the corporation to court over the fairness and lawfulness of an election that was about to happen but didn't yet happen. And they've specifically asked the court to proactively appoint a neutral and disinterested chair, as they thought the person who was going to chair on behalf of the corporation was somehow politically aligned with the other side. And there's going to be some sort of shenanigans. But the court basically said that they're not going to intervene to enforce some sort of corporate governance procedure for a condo where there isn't actual evidence of any real or true harms. There's a certain legal test is required for this sort of preemptive injunction, let's call it, and that was not available here. But I mean, a lot of to take away the best practices from this is, I mean, keep in mind, look at your governing documents, see how the chair is supposed to be appointed. But I mean, even if your governing documents might permit a certain person who may be running for that very same election to be the chair, I mean, you could always consider a procedure where that person either steps aside for the meeting, or for that portion of the meeting, someone else takes over and runs the election. Or you could, consider retaining a third party to the chair of the meeting. Like a lot of the electronic voting platforms offer this service. A lot of law firms offer it as well. So take away from this, the court is not necessarily going to jump in and change how an election is about to be run. It's more the case that if something goes wrong, or you have some sort of procedural inequity or unfairness issue, that you could then challenge how the election was run, or the meeting as a whole was run. But the court is unlikely to just jump in and assume wrongdoing and impose corporate governance procedures on a condo.
Sure. So don't cry wolf before somebody gets eaten by the wolf. That's great. Fantastic lesson there. So Graham, maybe you can launch the poll. I don't know if anybody wanted to sort of comment on that. Anyone? I don't think we assigned this one to anybody as a reply, eh? No? Okay. So an interesting case, mainly because somebody went to court proactively ahead of time before anybody got burned. And basically the court said, well, you could just wait it out. In fact, it may not matter at the end of the day. I mean, if the results of the votes are like so one-sided, it may not really matter. Okay, so let's have a look here.
And Justice Myers found a way to throw a fiddler on the roof reference into his judgment as well.
I love the way he writes decisions. That's fantastic. Okay,
well,
so
speaking of one-sided results.
Yeah, are you sharing that? So everybody agrees with the outcome of this case. Okay, wonderful. Let me go through the agenda, and then the next person we have in line is going to be Sonia. Sonia, you get, and you'll have to tell me which case you're tackling, but you're getting the first noise case out of the cat. I think that's what you're going to talk about, right?
Yeah, I'm going to talk about York Condo 229 and Roxon, which is the first actual decision on the issue of a noise complaint. There's been a lot of procedural nuisance noise decisions that have come out this year, but so far, but this is the first one. And I just checked this morning, there hasn't been one since this that's been released on the actual sort of substance issue of noise. It's a bit of a disappointment, this case, because the owner who had the complaints against them didn't participate. And so it was almost kind of like a slam dunk for the condo. So, this is the first official case on noise that came out, but I don't think it's really the first case on noise until we get both sides at the table and arguing it. And it'd be interesting to know if there would be a different result if the owner actually participated in the hearing, because I think that's something that we've seen in CAT's decisions over the last couple of years. They don't like when you don't participate, and they've heavily penalized condo corps who don't participate in the process. And I think this is an example of where they actually penalize the owner, probably more than they would have had the owner participated. But it is a good case from the condo's perspective on what you should be doing in preparing for going to CAT on a noise complaint. This one is a bit extreme. I mean, they had 94 incident reports between August of 2019 and March 2020 with respect to noise complaints. And they filed all that as evidence. So, good for this condo, document. They did the right thing in doing that. And so they had a lot of evidence before CAT that was not at all disputed, that showed that there was ongoing noise complaints. Interesting thing, the condo's application started as a breach of Section 117, and just a reminder to everyone, Section 17 got amended to include now any unreasonable noise that is a nuisance, annoyance, or disruption to an individual in the unit or common elements now falls under Section 117. So their application was based on Section 117 and on their rules, the nuisance noise provisions in their rules. But the interesting thing is CAT found that there was a breach of the rules, but they didn't find there was a breach of Section 117, which I was kind of surprised. It would have been nice if they had also made that finding. But unlike Natalia's case, the great result in this case is the condo got fully reimbursed for all of their costs, almost close to $10,000 at the end of the day against the owner. And so I'm really happy to hear that CAT is, prepared to make those cost awards because it's very sad. Natalia's case is sad to me because owners who have tenants, they're in it for profit, but condos are not in it for profit. And so I don't think condos should have to pay for owners' tenants. And then the owner just gets to, be in the business, but not have the risk. So it's nice to see in this case, although it wasn't a tenant case, it's nice to see that the CAT ordered the owner to pay all of the costs. And the other nice thing is in the language of the decision, they reiterated the common language we used to see in the court decisions about innocent owners shouldn't pay. And owners have to be responsible and have to comply. So it's nice to see that language coming into the CAT decisions.
Yeah, no, that's fantastic. A couple of questions. Let me ask you this, and I'm not sure if somebody was assigned to discuss this with you, and if so, raise your hand. But what was the nature of the noise disruption? Like, was it music? Was it partying, bowling? What was it? You may have said it.
It was playing loud bass music after 11 p.m. was part of the complaints. It was music based.
Okay. And was there any sort of discussion? Because I think you indicated that the noise started in August 2019. That, unless I hit my head on a pole, that's before the CAT got jurisdiction over the noise disruption, right? So was there any discussion along those lines? The fact that the noise took place before the CAT had jurisdiction over it?
No, they didn't. I think probably not, because there were so many more incidents since they've had jurisdiction that it really didn't become an issue, but they didn't discuss that. The one interesting thing that actually came out of the case, though, that they did discuss is the condo wanted to get an order, basically a preemptive order that if the owner didn't comply and stop the noise, that they could go in and soundproof the owner's unit and the neighbor's units. And the CAT wasn't prepared to do that order, really on the basis that the condo didn't come with specific enough criteria to determine if non-compliance actually existed. But that was the only other, interesting discussion that sort of came out of the case.
Okay, so Graham, if you want to launch the poll. So this was the noisy case where somebody was playing loud music and the corporation got all of its cost. So we're launching the poll, and while this is happening, I will go to the agenda. We'll look at the next speaker. And in the meantime, folks at home, every time somebody starts to speak, I put the case citation in chat so you can have a look at what the case is about. Oh, we're turning to the condo triplet, the third condo twin, Jason. You are going to discuss a pet case. Are you going to tackle, which one of the two are you going for, Tenno or Tammo?
Tino.
Okay, well, go ahead and maybe set the table for the case before you dive in.
Perfect.
Before
Thanks,
you
Rod.
do, hold on. I just want to say, Sonia, good job selling your thoughts on that one. Everybody seems to have agreed.
It's unanimous. Yes, fantastic. Okay, go ahead, Jason.
Okay, so yeah, we're going to talk about Tenno and Essex Condo Corp 28. So this case actually comes out of Windsor, hometown of Windsor. I'll see you this weekend. So some quick facts of the case. The declaration of the condo actually prohibited pets and other animals. But in true condo fashion, many of the boards over the years, they actually failed to enforce strict compliance with the no pet provision. Specifically, some cats were permitted on the property from time to time. The board made a decision that it wanted to reinforce its declaration. So it decided to create a rule which established that legacy cats were permitted on the property, but no other pets were permitted. So that would include new cats as well. So Mr. Tino, a unit owner, he bought his place in around 2016, and his position was, I assume that I was buying into a no pets condo, which, by the way, is a bit of a strange thing, right? The whole no pets condo thing, but I digress. He contended that the new rule that was created was unreasonable because the corporation didn't take reasonable steps to resolve the non-compliance issue before it had enacted it. So what he suggested was that the rule specifically was invalid because it conflicted with the provisions of the declaration. So you have a rule that says we're going to permit these legacy cats. You have a declaration provision that says no pets, full stop. Pretty good argument. So he suggested that the board of directors exempted themselves from the no pets provision. They had cats, some of them did, previous and current, and alluded to the fact that this was just a mere attempt to permit their pets. So the tribunal didn't buy this argument, but it didn't resolve the case. There was some more argument, and ultimately a decision had to be made. So I'm going to kind of go through some of the arguments raised by both parties. So the corporation or the board testified that there was inconsistent enforcement. So they acknowledged that, but they said that only cats were ever permitted. So once owners asked to have dogs on the property, the board said, okay, we need to address this issue. We need to take steps to implement the no pets provision. And they concluded that the owners of the legacy cats would likely be successful in resisting attempts to enforce the no pets provision. And as a result, they sought legal advice to address the matter. For this reason, the corporation ultimately ended up passing this rule, which says we're going to permit these legacy pets, but otherwise no pets, full stop. So one of the questions that was raised by the owner, Mr. Tino, was whether the rule was an attempt to amend the declaration. And as you know, the process to amend the declaration, 80 or 90% consent, much different than passing a rule. The tribunal concluded that the rule was not an attempt to amend the no pets provision in the declaration. Therefore, the procedure to pass and adopt the rule was permitted. Both parties brought forward this old case. I don't remember the name of it offhand, but what it more or less said was that an owner had a cat for 10 or so years. The condo asked to remove that cat, that there was a no pets provision in the declaration there as well. And in that case, the court found that the corporation couldn't now take steps to enforce the no pets provision against the owner. So considering that case, the corporation said, we made a decision to pass this rule so as to reasonably enforce the provisions of the declaration. We're balancing the interest of those that have cats and have had cats for a number of years at the corporation, and then also simultaneously trying to enforce the declaration provision. Owner argues in counter that the case that they're referring to actually just simply demonstrates the court's power to choose not to enforce a provision of the declaration, but that it doesn't necessarily equate to the corporation or the board having the right to selectively enforce its declaration, which frankly I thought was another good argument. So in response to all of this, the corporation says that we're passing this rule, we think it's reasonable, we think it balances the rights of everyone. And the new rule was, and this is a quote from the decision, which I think is a pretty good quote, is a bridge to transition the corporation from non-compliance with the no pets provision to compliance. When you put it like that, it sounds pretty good. So what did the tribunal say? It concluded that the rule was a reasonable effort to bring the corporation into compliance over time, while simultaneously balancing the rights of owners of cats. And I think the decision is a smart way to bring your corporation back into compliance. And it's really not a novel issue here. These types of issues, condo corps across the province deal with probably on a regular basis. Either they're turning a blind eye or sometimes don't even know about a certain provision in the corporation's governing documents, which results in a failure to enforce. For example, residents are storing items in their parking units, right? Corporation doesn't enforce for a few months. All of a sudden, 20 residents are storing items in their parking units. 2 years later, it's 100 residents. So these issues happen often. It's a breach of provision of the corporation's governing documents. You'll need to review whether you can rely on the waiver provision in the declaration, or if some type of middle ground needs to be made. In some circumstances, notices can be sent out to all unit owners, providing an opportunity to come back into compliance with a certain deadline or time frame, failing which the corporation can take direct enforcement steps. In other circumstances, like this case, when you're dealing with pets, more strategic decisions perhaps need to be made. I think the one thing to keep in mind here is that if it's a breach of the act, I don't think you necessarily have to follow this process. I think you can raise pretty good arguments to take enforcement steps immediately. If it's a breach of the corporation's governing documents, perhaps you're on different footing. And in this case, I think the corporation with its counsel, they did a great job of bringing them back into compliance.
Okay, interesting. I wonder though if you ever needed that rule to begin with. I mean, so the declaration already sort of prohibits cats. I wonder if there would have been another way to get to the finish line, because a part of the rule it prohibits cats, and you already have that prohibition. I wonder if maybe a policy or something like that may have reached the same objective. I'm not sure. There's a question from the readership, I guess. Jason, your introduction included a comment along the lines that a pet-free condo is a weird thing or something along those lines. Why do you say that? What's odd about it?
It's a thing to me that I'm a dog guy, so
There it is.
and maybe that's what it is. But to me, if you don't like animals, I don't know, something's got to be wrong with you a little bit. No, am I mistaken?
Can I piggyback on that?
Go ahead.
Because what's going on behind the scenes here, and Jason, I don't remember if you told us how many pets were subject to the legacy.
39, I think, or so.
Unbelievable. Well, so was it treated in the decision of what's the alternative? What does Tenno ask be done with the cats, dare I ask?
There's really not much discussion there, right?
Yeah, there's only so many different ways to skin a cat, I guess.
Well, that was back pocket. You're waiting to use that.
Okay, so there it is. Before I change speakers, a good comment from David in the chat line. He says the Legacy Cat sounds like a rock band, and of course the lead drummer would be Patrick Greco. Okay, so let's go to the next speaker. Jason, you're up. Jason is going to talk about this case, which dealt with an oversized truck that was nearly too big. So go ahead. I'm going to put the citation in the chat. Is this the 2745 case?
Yeah.
Okay, perfect.
Yeah, Toronto Standard Condo 2745 against Isla or Isla. Yeah, this case, it's a short read. I like it. I like it because there's photos. But so this case, Toronto condominium, high rise, underground parking garage, and the declaration has a provision that says, among other things, that owners of parking units shall not permit any portion of a vehicle to protrude beyond the boundaries of the parking unit and encroach on any portion of the common elements or another unit, which is a fair provision. And the case starts with the applicant suggesting that so it was a pickup truck parked in the unit, and the applicant claimed that the pickup truck was protruding the boundaries and blocked/obstructed the drive aisle and turning radius for other vehicles.
Okay, Justin, I'm going to stop you there. I'm going to show the first picture, okay?
Yeah, so this
this is the first picture, but I'm saving the second picture, the after.
Perfect.
There it is. Go ahead.
Yeah, so what I love that there's photos, and I didn't look at them until I finished reading the decision. So it starts with, right, there's a rule, you can't protrude. The applicant says they're blocking the drive aisle. Okay, that's fair. All right, we have a potential issue here. And the CAT in this decision found that there was non-compliance, or they say technically not strict compliance, which is just non-compliance, because you either have compliance or non-compliance, I think. But there was non-compliance, but the non-compliance was so negligible that the intent of the provision was maintained. So the CAT found that the CAT decided, yes, the declaration is clear, and yes, there's potential indication that the vehicle was protruding, but it's really not protruding enough that there's any issue at all. The CAT suggested there was really no evidence of any harm or anything related that would pose a problem and need this to be litigated. So that photo on the screen is the pre-compliance photo that was taken by the applicant to suggest that the vehicle is protruding. And there's the Schedule B photo, which is the after compliance, which shows that it's still protruding a little bit out of the barrier. But you look, and I laughed when I saw these photos, because you read the decision, and it seems like there's a problem, right? There's being obstructed. We can't have the obstructions. But then you look at the photo, and there's about a 3-car length lane road that you can drive down this drive aisle. So this case is, I think it's a good case just to show, just to be reasonable, I guess, and how people want to carry out their extracurriculars and complain. Now, like that said, I think from the legal positivist in me says, the declaration says you can't protrude parking space. The vehicle protrudes, although they never actually measured, and you can't tell based on the case that the actual boundaries are the outside of that pillar. So it could be the case that the parking unit actually was extended a little bit farther out, and they never fully measured. But it just shows that I guess that just there's some discretion with CAT, and that if there's really no harm, then no foul, and that is the nature of this case. That the intent of the provision was met.
Okay, so we're going to launch the poll, Graham, if you want to prepare that. And so the outcome of this case is this. There was a breach at this point, but when the driver removed the bicycle that was in the back of the motorcycle, and so at the end of the day, CAT said, listen, there's a technical breach, but everybody go home, get a hobby. Like nothing to be seen here. So do we agree with this? And in a minute, Graham, you're going to share the results. Okay, now let's move on.
We seem to agree. Hold on, I'm ending the poll.
You're gonna share that? Okay, and Justin, I've called you Jason on more than one occasion, so sorry about that. It's obviously Justin Black.
I get that all the time.
You do,
can call me whatever you want. I do not care.
Nice. Okay, thank you so much. Thanks for that case. And
before too.
What was that, Graham?
I said you've been known to call me David before too.
Really?
Oh yeah.
Like,
It just,
you know what? Now we know who's the
bearded,
favorite one.
The bearded lawyers on this call are just blending together.
That's right. Okay, so let's move on to the next case. We're still in time, actually, so that's all good. Did you share the results, Graham?
I think I did. Yeah, I can do it one more time.
Okay. So the next case is going to be introduced by the lead drummer of the Legacy Cats. It's going to be by Patrick Greco. And so Patrick, you will be discussing, let me just get, I'm trying to get my my cheat notes here. Where is that? I can't do it when somebody's sharing the results. That's the issue. Let me just go here. Well, I'm actually flying without instruments here. I have no idea what you're going to talk about.
No problem.
So just take the floor.
It's MTCC 1260 versus Sing. Sing being the unit owner, which is an important part of this. And I'm going to take one big breath and give you what should have been 2 years of litigation that happened in 3 months. And the entirety of this litigation was handled by Justice Myers with his typical flair and directness, which I think really helped the results. So this is a case that our office was involved with, where the client successfully obtained both a compliance order and an eviction against 2 tenants in court, where their dogs and their conduct had basically terrorized the community. And the evidence in the case was pretty disturbing. There were 2 pit bull type dogs, and they were permitted to roam around the building corridors unsupervised and unleashed. The dogs lunged at other residents and dogs, and there were numerous complaints, including a serious incident of injury to an individual and a dog. Okay, you'd think, well, no brainer here so far. The city of Toronto issued a dangerous dog order requiring muzzling. The tenants did not comply. In January 2022, so this is when the stopwatch starts, the condominium sought and was granted an urgent application date and a court order requiring the tenants to remove the dogs from the unit and the property. And of course, the tenants did not initially remove the dogs. And so the condo obtained the assistance of the sheriff and animal services to remove the dogs. And during that process, one of the tenants said, well, we're going to go to the breeder and get the 2 loudest German shepherds that we can find and let them loose in the building hallways. So we went back to court on February 11th and asked that the tenants be evicted from the building. At that time, His Honor wasn't comfortable that it was ripe just yet, but confirmed that they were, quote, irresponsible dog owners and incapable of managing pets in a manner suited for communal occupation and use of the common elements, and issued an order that not only they have to get rid of those 2 dogs, but they may not keep any dogs on the property. We're here talking to you today, so sadly that was not the end of the saga. By early March 2022, the owner went in the unit and found pee pads, bowls of dog food, and water in the unit. The condo also found, of course, bags of excrement on the common elements, including on the balcony below. And His Honor put 2 and 2 together and said, well, you know, likely who's going to do that? Someone who's trying to hide the excrement, although didn't do a great job. Another hearing was scheduled for March 11th to have the tenants removed. And what's interesting is that this was brought by the owners, who were highly cooperative and proactive throughout. As we've touched on earlier, and I won't belabor it, normally that's brought to the Landlord-Tenant Board, but because of the danger and because the Condo Act does allow in certain circumstances termination of tenancy, the court did accept it, although it is still rare. His Honor found that the tenant's conduct amounted to deliberate deception and deliberate violation of the statute, as well as the breach of 2 now court orders. He found that they were unsuited for communal living and communal use of property. There's so much good stuff, but I'll spare you in the interest of time. Interestingly, the court reviewed the amendments to section 135.1 of the Condo Act. And that's where it has been, it's not proclaimed yet, but it pairs back the general eviction powers of the court to say that it can only be done where there is a breach of 117, being safety and security under the Condo Act. His Honor said, look, even though that doesn't apply here, I would have said it applied anyway, even if that was the test that was in force. All in all, the condo obtained 3 compliance orders. This is where it gets bonkers. It also ultimately received full indemnity costs against the owners and tenants for $48,635. And the owner was ordered to pay jointly and severally with the tenants. And His Honor said, look, I wouldn't do this. They've been very cooperative, but for your declaration indemnification clause. So all over the map with cat and court and all things. So, the condo caught a real lucky break on this one. Of course, those owners were also given a right of recovery against the tenants, but if you get a flavor for these tenants, you're going to figure out that that owner is going to have a tough row to hoe to collect. But I can tell you, things aren't always in the reported decisions. The owners took their own small measure of justice. When the eviction was being executed, one of the owners allegedly punched one of the tenants in the face.
Oh my goodness.
Probably out of the realization that they just cost them 50 grand. A couple takeaways. The CAT normally has jurisdiction over pet things, as we now know. However, the Superior Court agreed to hear the matter as opposed to deferring to CAT because there were allegations that the tenant's behavior triggered Section 117. But as always, condos and council should be careful not to abuse that request. The entire process took a miraculous 3 months to complete, which in court time is super fast. Thanks mostly to the case management by Justice Myers mostly, and him taking an interest in this. And another takeaway, which has already been touched on, is that owners need to be careful with the tenants they choose to occupy their units. In this case, despite the owner's cooperation, and they had their own counsel and everything, they ended up getting dinged pretty badly in the end.
Okay, wow. You know what? A couple of things actually. While Graham prepares the poll, something that stuck out for me is the fact that we still have sheriffs. The fact that you can actually go and get the sheriff to go seize dogs or property. So that's the first thing. The other thing, I do find that there's a bit of a leap to conclude from the presence of PPAD to conclude that there's an animal in the. And don't you think? I mean, anybody could be using that, right, Patrick?
Different strokes for different folks. I don't know what goes on at this condo.
Okay, so are you going to share the results, Graham?
I sure am. Here we go. And
so most people agree with the outcome so far. Only Sonia, I think, has the perfect score so far. Okay, perfect. Thanks so much. Graham, you are going to close the parade. You are going to also cover a vehicle case, the case of the leaky car. So go ahead, and I'm going to share the name of the case.
So this case, which is called MTCC 818 versus Tessin, it was a case before the CAT as well. And what basically happened was this condo had a rule that said that if you're going to be parking your car in the parking garage, you can't allow any sort of dangerous situation that risks safety or security to continue to exist. And if you do for more than 72 hours, then we can have your car towed. And essentially, there was a car that was parked by this owner, and it was seeming to leak. And the corporation wrote to him at one point without hiring lawyers. He did some sort of fix to his car, seemed to resolve it, at least for a couple of months. Fast forward a couple of months later, the leaking begins again, and the condo, instead of writing to him directly this time, goes straight to the lawyer. The lawyers start sending legal letters, and the guy keeps pushing back that, I don't actually think my car is leaking. I don't know if this black oil smelling substance under the car is actually oil. And so they keep having some exchanges, and eventually the condo feels as though it has no choice but to go to the CAT to help it enforce this rule. And so it goes to the CAT, and it essentially asks for two things. It asks that, one, the CAT or make a finding that this person has been in breach of the rule, and two, that the CAT order that we the condo be given access to this parking spot so that we can clean up and fix the damage that's been done. And so there's a whole hearing, evidence is exchanged both ways. The owner continues to maintain that there was never an oil spill. I don't know what this is, but in any event, at some point after various fixes to his car, it seems to have resolved the issue and the leak stops. And the CAT finds that based on the evidence presented, it does in fact appear that your car was leaking oil and causing a dangerous situation. So on count number one, you were in breach of the rule. And then it finds that on count number two, you do have to give access to the corporation to go in and fix and clean this spot up. And the CAT noted that, and this is probably one of the important factors for maybe when it comes to costs, how this all shook out. But the CAT noted that number one, the Condo Act already gives condominiums the authority to come in and access a unit on giving reasonable notice. So it made this order anyway, but noted that that authority was already within the condo. And two, it also noted that, it's a little strange perhaps that your rule condominium already gave you the ability that if in 72 hours the issue isn't resolved, you can tow the car. And the CAT found that that would have been a perfectly reasonable thing to do, but for some reason you never did that, and here we are. But essentially where this left the condo was a situation where it won on everything that it was seeking the CAT to do. And so the question then became, as it always does, well, what do we do about all these legal fees? And this is a case very much unlike what happened in Patrick's, because the condo essentially was asking for a couple of things. It was asking for its engineering fees. It was asking for the fees to clean up and fix the parking spot, and it was asking for its legal fees. With respect to its engineering fees, those were off the table. And I think I agree with that. A lot of the engineering opinions and stuff that were obtained, including time to prepare the engineer for giving their witness statement, that's not something that the CAT usually would have awarded. In terms of the cleanup fees, those were ordered that, your car has leaked on this unit and caused damage, and you have to repair that. And that was to the tune of about $1,800. But then the big ticket item was the legal fees, which was, I think, $16,000 in all or something like that. And the CAT found that we're going to split it into two groups: the legal fees before you came to the tribunal and the legal fees after the tribunal process started. For the before you came to the tribunal, it ended up giving them about 2/3 of their fees, and the only ones that it said you're not going to get awarded were that first legal letter, because it found that maybe you kind of jumped the gun going straight to the lawyers when you already have shown that in the past a letter from the board did the trick. In any event, the later legal fees, sure. Once we get to the CAT, the $14,000, the real where the money was, the CAT found, again, that similar to the test Natalia was talking about, that there weren't any exceptional circumstances here. And it talked about the Sofamis case, which we've described here quickly, and said that that's an example where, we've got a breach of the governing documents that's taking 3 years and it's happening on purpose and in bad faith. That's an exceptional circumstance. But here, where it's, I guess, a breach that's occurring for 6 months and, the owner's trying maybe to do some stuff to fix it, that's not exceptional enough to award costs. Now, as Natalia mentioned, the test for costs has changed. Would it have mattered in this case? I'm not sure. But one thing that I think gives me a little bit of pause here, I think it's a little bit unfortunate, is that, the condo did get all of the orders it was seeking. The person was in fact breaching the rule. And it may well have been that even though the condo had the authority to go into the parking spot and fix the mess, there's an argument to be made that maybe without this order, it wouldn't have been able to do so very easily. And so I don't know. I think it's a bit of a shame that the corporation got stuck with its prize for winning this was a $14,000 legal bill. Although maybe the lesson here is that sometimes the cost of doing business as part of a corporation means that you're going to incur some legal bills. And when you're looking at a mess that's going to cost about $2,000 to clean up, do we want to spend $16,000 to get there?
The music is about to start playing. You missed the cue when the poll showed up there. That you were at the time there, Grim. Oh my goodness. Okay, no, thank you so much. Yeah, that's right. Thanks so much. So let's see if people agree with the outcome of this decision, and that's going to conclude our first annual Low Law Palooza webinar. I hope you enjoyed it. Let me just go around the table one quick time to sort of thank our speakers, and then after that we will sort of part for the summer. This is the last episode before we take a break, a 2-month break for the summer. Let me go back to my list of speaker here, and in no particular order. And again, I need another screen, folks. This is what I want for Christmas, just yet another screen. So let me go in no particular order from Robson, Carpenter, Justin, Black. Justin, thanks so much for being with us tonight. Any parting words for the summer, Justin?
No, not really. Just enjoy the sunshine every moment you can.
Okay, with a shovel, preferably. Perfect. Sonia Otis of Otis Law, any parting words for the summer, Sonia?
Yeah, I sure hope Kat's going to follow Justice Myers and Marianne Spencer in my decision, and we'll be seeing some more positive cases on costs coming through Kat over the summer. That's my wish.
Okay, crossing our fingers here. Sonia was presenting on the case of the owners breaking the sound of barrier. From Lash Condo Law, Natalia Polis, the axe throwing condo lawyer with the case on its raining cats and dogs from the balcony above. Natalia, any parting words for the summer?
So I do have some. Stay tuned because I'm working on 4 noise cases. So we'll see how those go before it can. Hopefully we'll get some good decisions. We can talk about them next year.
Yeah, maybe we can have a special episode on noise. From Miller Thompson, Jason Rive, who he covered the pet-free condo, which allowed cats, and he's clearly a dog person. So now we know why he picked that case, maybe. So Jason, any sort of parting words for the summer before we part?
I'm just looking forward to getting the legacy cats together and continue rehearsing.
Nice, perfect. Thanks so much. And of course, the 2 condo twins. Graham, parting words?
I guess if this is your lifestyle, just remember that pee pads probably not best kept in your unit during the summer. And otherwise, like Justin said, try and get out there and enjoy some of the weather while we've got it.
Wonderful. David, you're going to get the closing words here. Parting words for the summer?
Well, I see on my Twitter feed that Johnny Depp was substantially successful in his defamation lawsuit, so we can all get back to our lives now. So enjoy the summer and don't forget to vote.
Yes, oh, for sure. Absolutely. That's tomorrow. Okay, and so my usual goodbyes here. Let me just move here. What do we got? These are the cases. Next webinar is going to be on September 7th. One last thing I would need to say about this webinar is that no animals were hurt in the production of this webinar, despite all the crazy cases that were presented. It's usually not a bad pet. It's usually a bad owner. So next webinar is on September 7th. The information will be posted on Condo Advisor. You'll need to register again. Some people are asking us if there's going to be a rerun of this episode. For sure. In a couple of days, we will post it. All you need to do is go to the Condo Advisor website, click on webinar, and if you click on that, you'll be able to see past webinars on demand for free. Fantastic. And so that's it for me. We've done, I forget now, I think we're at episode 34. These are a lot of fun to put together. If you have any suggestions for topics, please send them our way. And we're going to take a summer break. Keep wearing a mask, get a vaccine shot if you're able to. Be respectful of each other. We have different views, different tolerances to risk. And that's it. That's my usual sort of Bible thumping moment about COVID. I had to say the word COVID in this webinar. Otherwise, it wouldn't be a webinar. Okay, so thanks everybody. Thank you very much. It's 6:03. We went over time. Thanks everybody around the table. See you on September 7th.